Good afternoon. On behalf of Stetson University College of Law and the Stetson Law Chapter of the American Constitution Society, I want to welcome you all to today's luncheon panel, Taking on Citizens United, Short and Long-Term Strategies to Restore Our Democracy. To the members of our panel, we are honored to have each of you as our guests. And thank you to everyone who has joined us here in the audience in Gulfport or via the web in DeLand or beyond. Professor Joseph Morrissey will be introducing our distinguished panelists in a moment, but first, I wanted to take a moment to thank several organizations whose support and partnership made today's event possible. I'd like to thank the American Constitution Society for Law and Policy, American Promise Tampa Bay, Free Speech for People, the League of Women Voters of the St. Petersburg area, and the Leif Neeson Foundation for a Better World. Thank you very much. And several of the organizations have provided some materials at your desk or in the back of the room as well. Today I have the great pleasure of introducing today's moderator, Professor Joseph F. Morrissey. Professor Morrissey received his A.B. from Princeton University and his J.D. from Columbia University School of Law. We are fortunate that he joined the Stetson Law family in the summer of 2004. He has taught and published in the areas of contracts, constitutional law, corporations, securities, and international private law, including publishing about the case that brings us here today, Citizens United. With that, please welcome Stetson's very own Professor Joseph F. Morrissey.
Thank you, Nathan. So, thank you all for being here. As you all know, Citizens United just a few years ago is the seminal case where the Supreme Court had decided that corporations should have human free speech rights and not be restricted in the way that they contribute to campaigns. Justice Scalia, I thought, was sort of amazing in that opinion when he said that had the Supreme Court not wanted corporations to have that right, they would have carved it out in the First Amendment with a parenthetical or something that said free speech for everyone but corporations, which I find pretty remarkable. Nonetheless, he was able to achieve the result, right, of unleashing really an enormous amount of money into politics. And later, of course, we see another Supreme Court case unleashing money through super PACs. And these are going to be the topics of the day today, to try to figure out if there's a remedy. If it's a problem, I suppose, although I think our panel probably unanimously believes that it is, and sort of what that remedy might be. And we are really lucky today to have Commissioner Ellen Weintraub from the FEC, Professor Al Schuler, Emeritus from the University of Chicago Law School, St. Pete Councilwoman Darden Rice, and Scott Graytech, who's counsel with Free Speech for People. So we're going to start with about 5 minutes of commentary from each of them. I'll introduce them sort of as they go in a little bit more detail, and then we'll take questions from you all. We are also live streaming with our DeLand campus, and we welcome them as well. And they are absolutely invited to submit comments through the web, and those comments will come up to the panel for our consideration also. So, to start, we're going to have Commissioner Ellen Weintraub. She's with the FEC. She took office in 2002. Prior to that, she was private counsel with Perkins Coie, and before that, counsel to the Committee on Standards of Official Conduct for the U.S. House of Representatives. Commissioner Weintraub will provide sort of the big picture regarding the FEC's response to the current jurisprudence, the federal ban on federal spending, the loophole created by Citizens United, and the importance of local leaders taking up the cause given FEC deadlock. So, Commissioner Weintraub.
Thank you, Professor. Can you hear me? And thank you all for the very warm welcome here at your beautiful campus at Stetson. I've never been here before, and it really is an incredibly lovely place. And I'm going to go back to DC and tell all my friends this is just sort of a hidden gem down here. So here we are in 2016, 6 years after Citizens United. Everyone's heard about Citizens United. It's not the only thing that's bad about money in politics, but it does seem to have crystallized opposition to the current system. People really started talking about it more. People outside of my little election law geeky circles actually started talking about it. And this year in particular, it's become a really big issue. I read about it in on the front pages of the newspapers. So that's kind of exciting for me that, the whole country is now really focused in on this issue. And I think it's because the decision itself is so blatantly ridiculous, honestly. We have had jurisprudence for going back to 1975 that says there is an inherent risk of corruption in unlimited financial contributions to federal office holders, to federal candidates. They upheld the contribution limits based on that rationale in 75. They got that. And yet somehow in Citizens United, they came to the conclusion that there was no conceivable risk of corruption if the money instead went to an independent, and I'm putting that in quotes because that's become kind of a problem in and of itself, to an independent spending group. So you can have, this is where we are today, the current contribution limit for candidates is $2,700 per election. So it is corrupting, illegal, and wrong, and we punish people for giving, if they were to give $3,000 to an individual candidate for one election, but you could give $3 million to a super PAC that exists for no other purpose but to advance the election of that same candidate. And the Supreme Court thinks there's no risk of corruption there. Does anybody believe that? I mean, that's just a little bit crazy. So here we are, 6 years after Citizens United, and the FEC, due to institutional inability to act, we have a 3-3 commission. No more than 3 members of any one political party can be appointed to the FEC. For good reasons. People didn't want partisan control on the FEC, but the problem is that the Democrats and the Republicans on the commission are so ideologically divided on issues of campaign finance that we can't get anything done. So 6 years after Citizens United, we have done no substantive rulemaking about Citizens United and what it has created. So we've done no rulemaking to address, for example, problems of coordination. These super PACs are supposed to be independent, and yet we have seen super PACs that are created and funded by candidates' mothers, brothers, spouses. They're the people who ran their last campaign, and we cannot get 4 votes on the commission to even investigate whether any of those groups might conceivably not be so independent. We have had issues involving coercion. When corporations become more active in politics, the question is, corporations, they're really not people. So they can't actually do anything without having people implement the corporate message or the corporate political activity. That being the case, how are those people going to be chosen, going to be asked, how forcefully are they going to be asked to participate in the corporation's political agenda? And we have seen cases as recently as this year where corporate bosses were extremely harassing of their employees to try to get them on board with giving to the corporate PAC, for example, and yet again, we could not get 4 votes to investigate that behavior. Disclosure. There's much that we could do, even consistent with Citizens United, to enhance disclosure and to deal with the dark money problem of money flowing through 501c4s, 501c6s, all sorts of wonderful 501 organizations under the tax code. This is a law school, so maybe you've all taken tax law and you know what I'm talking about. These groups do not disclose their donors, and yet many of them appear to be fairly heavily involved in political activity, and yet again, this is an area where we have not been able to make progress, despite the fact that even in Citizens United, the court gave a really full-throated endorsement for the values of disclosure and how that can be beneficial to the system and allow people to judge motives and see who's in the pocket of which special interests. That's almost a direct quote from the opinion. and the issue of foreign nationals. This is an issue that I've been really focused on lately. The possibility that foreign national money could be creeping into our system by way of corporations, because most corporations in this country, there's a huge amount of foreign ownership of domestic corporations in this country. In addition, there are all of these 501c corporations or LLCs or other entities that don't disclose, and we're not really sure where they're getting their money from. I took another look at Citizens United and the way that both in Citizens United and, oddly enough, the Hobby Lobby decision, which you may have also read about, the court really focused in on the people who are behind the corporations in giving them these rights. They didn't actually say corporations are people, because even the Supreme Court doesn't really believe that, but they said the corporations are amalgams of people. There are people that the corporations are acting for, and those people don't lose their rights when they form corporations, and that's fine, but they also don't gain rights when they come together in corporate form. So if you are a foreign national and you are part of a corporation, you don't suddenly get rights to participate in our electoral process because now you're doing it through a corporation. And I wrote an op-ed about this in the New York Times, and it is something that some journalists have gotten kind of excited about and started to dig in and look to see whether this is a problem, and they're starting to see instances of this happening. And I'm extremely gratified that some of these ideas have made their way into Darden Rice's wonderful ordinance that she has been pushing for here down in St. Petersburg, where St. Petersburg has this wonderful opportunity to really be in the vanguard and to establish principles that can serve as a model for the nation on how to better address money in politics. I know I'm only supposed to speak for a couple of minutes here, so let me just broadly say that, where we are after 6 years of Citizens United is we're looking at an election where it is estimated that $6.6 billion will be spent in this, for the federal election alone, not even talking about state and local elections. And $1.7 billion is coming from outside groups. No, wait a minute, let me restate that. Fully 1/3 of the $1.7 billion that's being spent on the presidential alone, just on the presidential, is coming from outside groups that have no contribution limits whatsoever. And some of that is coming through dark money groups as well. So that is not an insignificant amount of money. And if you want to look at how all these outside money groups are playing, you can see it close to home, where about $40 million in outside money has already been spent in the Florida Senate race. So it is here, it is now, it is in your backyard. Every single poll that's been done on this issue has shown that people by wide margins, Democrats, Republicans, Independents, do not like the way we have our money and politics system organized, our campaign finance system. People are kind of disgusted with it, and I completely get that. And yet nothing changes in Washington, because despite all these polls that say that people are disgusted, people in Washington don't really believe that you care a lot about it. They think you may not like it a little bit, but you're not really going to be motivated to do anything about it. And this is where you all come in, because you need to prove them wrong. You need to be out there talking about campaign finance issues, questioning your elected officials on campaign finance issues, write them letters, send them emails, call them on the phone, show up at their town hall meetings and ask them politely but firmly what they're going to do about this, because they don't think you care. And until you show them you care, they're not going to do anything about it. Because remember, every single person who has been elected was elected under this system, and they know how to work it. So they all have an incentive to stay with the system they know. And while we're on the subject of activity, let me point out one more thing, because I can't resist whenever I'm talking to student groups, although I suspect that this is a pretty activist group by virtue of the fact that you are here today, and thank you very much for that. In 2012, a little less than half of 18 to 24-year-olds were registered to vote, even registered to vote, and only 38% did vote in a presidential election. Of those 65 and older, 77% are registered to vote, and 70% actually did vote. So if you want to know why Social Security is the third rail of politics, the thing that no politician will touch, And student loans are not. It's right there in that number. This is not about money. This is about voting, about getting out and vote and getting your friends out to vote and getting them to get their friends out to vote. You know, you would not let your grandparents choose your clothes or plan your weekend, right? So why do you let them choose your government and plan the nation's future? You guys are going to have to live in that future. So make sure that you have a say in it and that you hold every single office holder accountable to you to make sure that your needs are being met by your government.
That was outstanding. Thank you so much, Commissioner Weintraub. So we're going to move on to Professor Al Altshuler. He's, again, Professor Emeritus at the University of Chicago School of Law. He's written on a wide array of topics, most of them in the area of criminal justice. He's our resident expert on corruption and legal vulnerability of speech now versus FEC. So I didn't mention this earlier, but Commissioner Weintraub got her JD from Harvard, and similarly Professor Altshuler did as well. We're going to try not to hold that against them. Anyway, Professor Altshuler will discuss, among other things, his 2015 article that was published in the Florida Law Review that addresses these kinds of concerns, how speech now can and should be challenged, and the U.S. Supreme Court's shrinking framework for the corruption and appearance of corruption interest.
Thank you, Joe, and thank you, all of you, for being here. Let me tell you about America's zany system of campaign finance. I'll begin by echoing a point that Commissioner Weintraub made. The law bars hedge fund manager Donald Sussman from giving $6,000 to Hillary Clinton's presidential campaign. As Commissioner Weintraub says, $2,700 limit on each election, so you can give $2,700 in the primary, $2,700 in the general election, $5,400 is the max. The law also bars hedge fund manager Robert Mercer from giving $6,000 to Donald Trump's presidential campaign. And the Supreme Court upheld the law limiting contributions to candidates 40 years ago in Buckley against Vallejo. But the law didn't bar Sussman from giving $21 million to Priorities USA Action this year. That's a super PAC whose mission is to urge votes for Clinton. And federal law didn't bar Mercer from giving $15.5 million to Make America Number One. That's a super PAC that supported Ted Cruz in the Republican primaries and is now supporting Trump. There was a federal statute that once limited contributions to groups like Priorities USA and Make America Number One to $5,000 a year. But in a case called SpeechNow.org versus FEC, the DC Circuit held that statute unconstitutional. A super PAC is a political action committee that doesn't make contributions to candidates, but that does place its own independent ads supporting candidates and criticizing their opponents. They can't coordinate expenditures with an official campaign, but everybody understands in most of these super PACs that the job of the super PAC is to attack an opponent while the favorite candidate takes at least a somewhat higher road. So super PACs are the attack dogs and provocateurs of modern politics. Candidates they support don't need to take any responsibility for what they say, and the groups usually disappear once an election is over. The attack ads they produce contribute to the nation's cynicism about politics. So after Speech Now, our election law doesn't limit what somebody can effectively contribute to an election campaign, but it does require contributors to channel their funds to less responsible and more destructive speakers. And as I say, that's all upside down. No sane legislator would vote in favor of this regime of campaign financing, and no legislator ever has voted in favor of it. The United States has this regime because Speech Now held that the First Amendment requires it. And yet the thought that the Constitution requires it looks loopy too. According to the Supreme Court, Congress can prohibit a $6,000 contribution to an official campaign because that contribution is corrupting or creates the appearance of corruption. But according to the D.C. Circuit, Congress can't prohibit a $10 million contribution to a super PAC because that contribution doesn't give rise to corruption or the appearance of corruption. Clinton and Trump would be corrupted by $6,000 contributions to their campaigns, but they won't be corrupted by $10 million contributions to their super PACs. Now, how did we get to this crazy place? Well, in Speech Now, the D.C. Circuit didn't offer a word in defense of the merits of its ruling. It just said that a single sentence in the Supreme Court's opinion in the Citizens United case compelled this result. The Supreme Court said, "We now conclude that independent expenditures do not give rise to corruption or the appearance of corruption." Listen to that statement. That's a statement about independent expenditures, not contributions. Everybody thinks it's the Citizens United decision that allows Mercer to give $21 million to Hillary Clinton's alter ego super PAC. It's not. Citizens United didn't deal with campaign contributions at all. And for 40 years, the Supreme Court has distinguished between contributions and expenditures. It's consistently struck down expenditure limits while upholding most contribution limits. But what the Speech Now decision did was to treat the Supreme Court's statement that independent expenditures don't corrupt as the major premise of a syllogism. It said, well, if independent expenditures don't corrupt, then the contributions that make those expenditures possible can't corrupt either. It doesn't matter that different standards of review apply to contribution limits and expenditure limits because the government has no interest in regulating either one. The court says something beats nothing every time, and the government has no regulatory interest. Now, I think that syllogism isn't true. Think about the bribery indictment that's currently pending against United States Senator Robert Menendez. It alleges that a Florida doctor gave hundreds of thousands of dollars to a super PAC supporting Menendez in return for Menendez's advocacy on behalf of the doctor in a Medicare billing dispute. Well, this indictment doesn't contain any suggestion that the super PAC did anything wrong. Nothing about the super PAC's spending corrupted Senator Menendez. It was the contribution. And that's the way it usually works. It's the contributors to these organizations who've given us a healthcare system that's tailored to serve the interests of insurance companies and pharmaceutical companies as well as the public and so forth. Well, the D.C. Circuit's bottom line is that neither super PAC expenditures nor contributions to super PACs create even the appearance of corruption. And certainly developments since that decision have made this bottom line look silly. In this year's Democratic presidential primaries, a 70-year-old senator who described himself as a Democratic socialist received more than 12 million votes, 43% of the votes cast. The main part of a large feature of this candidate's campaign was that he wasn't going to take super PAC money. By the end of the campaign, the crowds would shout with him the amount of the average contribution that he received. Who remembers? $27. Everybody was saying, $27. And this candidate said of his opponent, "Are you qualified to be president of the United States when you're raising millions of dollars from Wall Street whose greed, recklessness, and illegal behavior help to destroy our economy?" This year's Republican presidential nominee emphasized during his primary campaign, "I'm self-funding my campaign. I'm not getting millions of dollars from all these special interests and lobbyists and donors that once they get it, they literally do whatever the politicians want. That's not going to happen." This candidate said in a primary debate, "These super PACs are a disaster, by the way, folks, very corrupt. There is total control of the candidates. I know it better than anybody that probably ever lived." He tweeted, "Sheldon Adelson is looking to give big dollars to Rubio because he feels he can mold him into his perfect little puppet. I agree." Last week, Final presidential debate of 2016, the Republican candidate said to the Democratic candidate, "I sat there watching ad after ad, false ad, all paid for by your friends on Wall Street that gave you so much money because they know you're going to protect them." In stump speeches, he referred to this candidate as Crooked Hillary. The Democratic candidate voiced similar concerns about the corrupting influence of unlimited political contributions. She said, "We need a Supreme Court that will stand up and say no to Citizens United, a decision that has undermined the election system in this country." So, perceptions of corruption, at least the appearance of corruption, is everywhere. It is ripping America apart. And this afternoon, a group of us are going to urge Councilwoman Rice and her colleagues to enact an ordinance for St. Petersburg that will limit contributions to super PACs involved in municipal elections. And that ordinance might just become the vehicle for bringing the issue before the Supreme Court.
Thank you, Professor Alschuler, and that's a perfect transition to Councilwoman Rice, who was elected in 2013 after more than a decade of experience in working for national, state, and local organizations in communications and issue-based advocacy campaigns for the public interest. She is the sponsor of the Defend Our Democracy Ordinance, which would abolish super PACs and limit foreign corporate money in our local elections. Councilwoman Rice will discuss her experience running for St. Pete City Council in an increasingly big money election system and share how and why local leaders and communities like St. Pete are best positioned to lead the fight for a better democracy. Councilwoman Rice.
Thank you. Thank you, Professor Morrissey. Hi, good afternoon. I'm Darden Rice, and I'm the Vice Chair of the St. Pete City Council. And even before getting elected 3 years ago, I was the president of our local League of Women Voters, which I've been very active with for years. And it's in my DNA where I see that nonpartisan, good government, and fair election issues are some of the most important foundational and fundamental reforms that we can be working on. And it's the ones that do the most work to address our trust and effectiveness in our local government, our laws, and our policies. And I'd like to thank and recognize that we have some League of Women Voter representatives here today and with American Promise who've been a great part of helping us educate the community about this issue. It's been brought up that perhaps poking the bear of Citizens United is maybe stepping outside of the traditional role of municipal government and as an elected city council member. And I would argue that it's not. As city councilors, we have a lot of responsibilities. We manage and we lead. We manage about a $550 million budget. We ensure public safety, which is both police and fire. We demand accountability and oversight. We make sure that our infrastructure is working for our citizens and look out for the future. And we're constantly looking out for taxpayer values. And we also plan and oversee major capital projects, whether it's a pier or a baseball stadium. But looking over the functions of our local democratic elections is our purview as well. There are prescriptions in our city charter regarding elections, redistricting, nonpartisanship, terms of office, number of districts, residency, initiatives, referendums, recalls, petitions, and even the dates of elections. The charter also sets forth what City Council may do by ordinance to address other election issues. I believe that reviewing campaign finance laws is an important way for us to continue to look out for the health of our local democracy. The proliferation of super PAC money is coming to local elections. As we heard Professor Alschuler just say, it's ubiquitous. We're seeing it on the left and we're seeing it on the right. It is at our doorstep. Are we ready for it? Do we want it? Is there something that we can do to be proactive to fend off the influence of unregulated dark money in local elections? Given the level of cynicism towards government, leadership, and politics, especially among our youth, I would argue that we cannot continue to risk alienating ordinary citizens from trusting and feeling invested in part of our local democratic institutions. We have got big problems to solve, and we need everybody. And what we don't need is dark money and unlimited corporate money infused in local elections. So my ordinance proposes two things, and the ordinance itself is relatively simple to understand. Number one, it tackles the use of foreign corporate money in local elections. A corporation contributing over $5,000 must verify that it's not partly foreign owned. And number two, the ordinance proposes to limit super PAC spending to no more than $5,000. Now, election law campaign law can be somewhat complex. I think I'm the only one up here on this panel who's not an attorney. I might be the only one in this room who's not pursuing a formal legal training. But I'm very glad that right now and then later today at our Committee of the Whole meeting at City Hall, that we are going to be joined by these national experts in constitutional, corporate, and campaign finance law who can help answer questions, put this ordinance in perspective because it could be very likely to be an important test case. They're here to help explain relevant case law and definitions and explain some of the larger ramifications of this very, very important work. And we're very glad to be here today with you as well. Today's Committee of the Whole meeting is our first shot across the bow to present this material to my colleagues. We met with the mayor and his chief of staff this morning. Our intent is not to land a final vote today. We've got a lot of material to cover, and I imagine there will be a secondary and maybe a third part to this discussion where we would look at, I estimate, maybe a final vote by late winter or spring. But what I am going to ask my colleagues, half of who I know are extremely supportive of this based on public comments, but I'm asking my colleagues to keep an open mind and to be patient as we wade through these legal issues. I'm going to ask them to be bold instead of skeptical, curious instead of doubtful, courageous and forward-thinking as policymakers, and to the extent that we should always be cautious and planful and conservative, let's apply that sense of caution and conservatism to the threat of dark money and foreign money in our local elections. I think we can do it. I think we should do it. And I'm very glad that we have some people who have come in today to talk to us and talk to my colleagues later today to help us walk through this first part of the introduction of the ordinance. So thank you again, and I look forward to hearing your questions at the end of our discussion.
Thank you, Councilwoman Rice. So we're going to move on to Scott Graytech, as I mentioned, Counsel for Free Speech for People. He's a two-time grad of Ohio State, that's undergrad and law. He has worked for several advocacy groups before joining Free Speech for People. He also worked in private practice at the intersection of civil rights and education law, and worked to defend indigent clients and promote criminal justice reforms at the Office of the Ohio Public Defender. Scott's going to discuss legal theories and factual records behind the ordinance that we're talking about today and the current political climate.
Thanks a lot, Joe. So, Stetson folks, it's great to be here. I've never been here before. I was saying earlier, no matter where you go in your illustrious and very influential legal careers, you are never going to have a facility that looks anything like this. It is going to be a sharp and steep decline in at least your atmosphere, so please soak this up as best you can. I also want to point out that immediately after this, starting at 1:45, is the Committee of the Whole hearing that Councilmember Rice was talking about. So if you're free, grab a friend, head down to City Hall. It's going to last about 2 hours. Also later this evening, starting at 7:30, there's an event at Temple Beth El where the Commissioner and Professor Al Schuler will be giving a presentation talking a little bit more in detail about the ordinance and bigger money and politics issues. So, my fellow millennials, 2016 has been a very big year for money and politics. Professor Alschul talked about, we had a candidate, every time he gave a stump speech, would say, enough is enough. We have a corporate-run, corrupt political system. We're hoping that 2017 is a year of taking action on those ideas. So this ordinance is really a first of its kind opportunity, and this will be led, regardless of where it comes out of. We certainly hope it's in St. Pete, but it will be led by local leaders, because as the commissioner said, the federal government is totally deadlocked on this issue. Congress is in no position to lead, and the FEC is in no position to clean up the mess that's been going on across the country. We have the prospect of there being a new majority on the U.S. Supreme Court, a progressive majority for the first time in some 45 years. And if we provide that court with laws and cases through which they can change the existing jurisprudence on money and politics, we can change the entire national conversation. We can change the legal landscape that all of us are going to grow up in. If some of us decide to have political careers or contribute to candidates of their choice, it can be a much better system, so please turn out to those events. So I like to position this in the frame of, Bernie Sanders had a lot of young supporters. I'm a young person. It's not like money in politics was ever not bad. President Rutherford B. Hayes, if you remember him, said that we have a country run by corporations, for corporations, of corporations. That was 150 years ago. Things are not, they were never great, but I suggest that they have never been as bad as they are today. You have situations now where super PACs are spending $1 billion in this election. And over half of that money, according to research done by the Washington Post, comes from an amount of people that can fit on the airplane that I'm going to take back to DC. So a smaller group of people spending more and more money than ever before in American elections. At the same time, you see foreign nationals, non-US citizens or permanent residents, who are spending money in American elections. We all heard about how the Russians may be trying to hack America's elections and influence the vote. We already know about an organization that's run by 2 Chinese nationals that spent over $1 million to a super PAC that supported Jeb Bush in California. That's on the record, that's been demonstrated. And there is an increasing role of foreign corporate money in local races as well around the country. Who knows Lyft and Uber? That's how I got here today, right? They teamed up to spend $10 million on a local election in Austin, Texas. The city council there had decided to impose a fingerprint. If you wanted to be a driver there, you had to pass a criminal background test via fingerprint. Uber and Lyft didn't like this, didn't fit with their business model, spent $10 million trying to overturn that law. How about Airbnb, the home share company based all over the world, headquarters all over the world? These guys are spending $11 million on New York legislative races this cycle to try and influence the New York legislature, which has put a target on trying to regulate that industry. So this ordinance addresses both of those components. It limits the amount of money that somebody can give to a super PAC, therefore making it not super anymore. And it would say to any corporation that wants to spend $5,000 or more to influence a local election in St. Petersburg, they have to certify that they're not a foreign influenced corporation. That in the aggregate, 20% of their ownership is not held by foreign nationals or a corporation that's majority owned or controlled by foreign nationals, and that there isn't a single block holder of 5% ownership that is not either a corporation that is majority held or controlled by foreign nationals or 5% block holder he or himself that is not a foreign national. So to give you a picture of how this is operating in Florida right now, if you look to the north, the east, the south, there are super PACs spending tens of thousands of dollars all across the state. You had super PACs in Miami-Dade County for county judicial races. You all have this report in front of you, Justice at Risk. This talks about how special interests try and influence state Supreme Court judges. The researchers behind this were able to show a correlation. You spend a certain amount of money, more decisions go in favor of you, right? There was a county judicial race, 2 of them in Miami-Dade. Super PACs teamed up to spend $250,000 trying to influence that. These are judges, right? Local judges. In Gainesville, in Alachua County, their city commission recently passed lower contribution limits. So the amount of money you could give directly to a candidate was decreased. What happened as a result? Super PACs started popping up. Instead of giving the thousands of dollars you wanted to give to the candidate, they gave it to the super PAC. Because, let's be honest, it operates the same way. It's getting the same amount of influence across, right? So all over the state and increasingly encroaching on St. Pete, you see this kind of spending. In Pinellas County, this year there's a school board election. One of the candidates in a school board election saw flyers dropped by a super PAC that's based in Palm Beach County that so far spent $160,000 this year alone. So this is a problem that's becoming more and more localized, and it's not just Florida, it's all across the country, whether it's mayoral races that are seeing millions and millions of dollars. City council races in Oklahoma saw $500,000. You see DA races, one in New Mexico that was $100,000. Increasingly, super PACs are not just a Washington, D.C. national problem. These are things that are being used more and more to exert localized influence on local races. So I want to leave a lot of time for questions, but remind folks, if you're able to make it to the hearing immediately after this, please come through. We'd love to see your support for the ordinance. And also our event this evening at Temple Bethel gets started at 7:30 and should be a great discussion. So it's great to speak with you guys today.
Okay, so thank you, Scott. We do have some time for questions. The first one came in from DeLand already. I believe it's for Commissioner Weintraub. Do you believe the disclosure of the John Doe files in Wisconsin will lead to additional regulations?
Okay, so I'm not in the weeds on the John Doe files, but for those of you who are just kind of scratching your heads and have no idea what this is all about, this has to do with an investigation at the state level into potential coordination between Governor Scott Walker and some super PACs out there, and the reaction to this investigation was pretty hostile, including by some state court judges that not only did they throw the case out, but they demanded that all the files be destroyed, which is a really weird thing for a court to do. But somebody leaked the files, and there's some hot documents in those files. Now, I have no jurisdiction over any of that because it's state level, and I only have jurisdiction at the federal level. But I can tell you that not only did Wisconsin not enact stronger rules in response to that, but they abolished the agency, which had been a neutral professional agency doing its job in Wisconsin, and replaced it with one more of the politicians choosing. So I don't think we're going to be seeing stronger coordination regulations at the state level as a result of that. Do we look at things like that at the federal level? Sure, but we've got plenty of evidence at the federal level that we need stronger coordination rules. As I said earlier, we have cases that involve people who are plainly intimates of the candidates who are setting up these super PACs, and because of the current situation at the commission, we can't get 4 votes to investigate any of them or to launch a rulemaking. I've introduced rulemaking measures at least half a dozen times since Citizens United, and every single time it goes down 3-3. So sad to say no, unless, as I said, more people start agitating louder. This could also happen in Congress. Congress could pass new laws on this, but we need to have members of Congress and members of the commission. Feel free to write to the commission. We all have public email addresses, so if you don't like the coordination rules that are on the books and you think we ought to write stronger ones, please send us your comments, and maybe my colleagues will be persuaded. But as I said, I think citizen activism is the only way to move things forward at this point.
Terrific. Okay, so how about from our audience here? Any thoughts, comments, questions? There we go. Thank you. So I think I heard you say, is it possible that we'd have a constitutional amendment that would say that corporations are not people, and essentially constitutionally overruling Citizens United? And somehow mandating that elections be publicly funded. Anyone?
Well, I'll tell you that the St. Pete City Council unanimously passed a resolution supporting such a constitutional amendment. And so this ordinance that we're discussing today is sort of a next step that falls from that. But I believe your group is also doing some work on the constitutional amendment front.
Actually, so this year in Washington, D.C. was the first year that there was an entire conference around the idea of passing a constitutional amendment. Some 17 states have already passed resolutions calling on Congress to adopt a constitutional amendment. It's on the ballot this year in Washington and California. This is something that the reform community, these can operate in parallel tracks, right? We can put test cases in the pipeline to try and change Citizens United and change speech now, but at the same time, the amendment is an excellent organizing tool for folks to be able to get awareness about this issue and bring people together to talk about other shorter, perhaps, term strategies that people can use to try and change the money in politics jurisprudence. But I would say from the results of what this conference looked like, it's folks from all across the country, bipartisan. This is an issue that 80% of people, regardless of party, support. And so there really is a growing infrastructure, and groups like American Promise, who are represented well in Tampa Bay, are leading that fight on the local level. And I'll tell you what, because she might not tell you, our own Ray Claire Johnson of American Promise Tampa Bay was given a national award at that conference for the work that she's doing on behalf of the Tampa Bay chapter.
Thanks. That's awesome.
Yes, give her a hand.
Terrific. Grant, did you have a question?
First, I would like to thank the panel for coming. We really appreciate it. My question is this. Oh, got a mic. This will make this easier, I hope. My question is this. So having more money in politics has increased the amount of ads, and that has brought awareness of elections to people who might not normally be aware of them, such as local elections, which have far more commercials than they used to have. Do you believe that putting limits will decrease the amount of this awareness because, of course, the advertisement will go down? And is there a public option to increase awareness?
I'll start. Well, the public option is public financing, and there are bills in Congress on this, and there are. This is another area where local action. Local actors are really leading the way. In New York City, for example, they have a really vibrant public financing system for city races with a 6-to-1 match for small contributions. And the advantage of that is that it gives a real incentive to politicians to go out and meet with a lot of people and try and drum up small contributions from a lot of people, because they get a multiple match for that and it's really worthwhile for them, as opposed to going out and having private meetings with only the large donors and spending all of their time talking to people who may not be representative of their communities.
I think with national races, it's a whole different beast, but I know with local races, and incidentally, when I was elected, I set the limit, I set the record for fundraising, and that was 3 years ago, and I think I raised about $118,000, all with $500 contributions. The state since then has changed the law to allow that to a maximum of $1,000 contributions. It really just goes to show that it's possible for a candidate with a plan and a strategy to reach those financial goals by going to individuals to reach that amount without having to depend on unlimited corporate money. But I would say that I think there's a qualitative difference and a benefit to the campaigns that are able to rely on grassroots measures to engage voters and to get the word out and to use earned media, rather than just kind of staying at home in the office and relying on TV ads and mail. Now, if you're running for a state race or a national race, then it's a little different. You obviously can't knock on all the doors you need to knock on in a big race, but with a smaller race, I think you see better candidates emerge who really get out the shoe leather and go and talk to people one-on-one, rather than just write big checks for paying for ads.
And we don't have to speculate on who's behind a lot of these ads. So I used to work on judicial elections alone, and you could see 100% of all attack ads that were ran against state Supreme Court judges in the last 2 years came from special interest groups. So it's just a different type. I don't know how high value information these attack ads are against judges. There's an ad that ran where a judge is saying he's a volunteer. He dives into the ocean when people are in trouble and ships go down, and it's an ad of him helping somebody out of the water. What does that have to do with being a judge? I don't know, but somebody thought it would look good on TV. So consider the value that you would have from having a council member come to your door or make a phone call, as opposed to that money going into an ad that talks about things totally irrelevant to the position that they're running for.
Yeah, I think most serious students of this problem think that the best approach to solving the money in politics problem is public financing of election campaigns, and there are lots of different ways to do it. I mean, we've been talking about contribution limits, and we're in favor of that, but that is not likely to be as effective as some kind of public financing.
We probably have time for one more question, if there is one. And here we go, John.
Coming in. I have a question about how you are to control foreign money coming into American politics when people are just as concerted as anyone else. They can just go and find another way to put the money in. How are we to think that if not through a foreign corporation, they can't just find a loophole and go through a national corporation owned by U.S. citizens?
Well, feel free. Part of the proposal is to say that domestic corporations have foreign owners, and we need to look at that. We need to look behind the corporation, even though it might be registered in the United States as a domestic corporation. We need to look behind that and see who is contributing the money, who owns that corporation, who's making the decisions about how that corporate money is being spent. Because if you are a wholly owned corporation in the United States and your owners are all foreigners, you really have a fiduciary obligation that in any spending that you do of the corporate resources, you have an obligation to be doing that in the best interest of the owners of the corporation, not in your own personal. People don't spend corporate money to, or at least they shouldn't be, to express their own personal views as the person who writes the check. So what we're trying to do, what I was trying to suggest, and what I think this ordinance is trying to do, is to get behind the facade of the corporation and at least have people certify that they're not using foreign money and the corporation is not a foreign influence corporation. I mean, you can have corporations that are registered in this country and are domiciled in this country. They might be wholly owned by a foreign government. Do we want foreign governments to be playing a more active role in our politics? I don't think so. There are companies that have fled the jurisdiction and organized themselves abroad to avoid taxes. Do we want those companies to be just able to set up a domestic subsidiary and continue to be engaged in U.S. politics, even though they're not willing to pay taxes here? You know, I would think not. You know, and there are a lot of other cases that one could bring up. But as I said, the Supreme Court actually opened the door to this because they said that the corporate rights really are dependent on the rights of the people behind them. So that's what we're trying to get at, is who are those people and do they have the right to participate in U.S. elections?
Yeah, and to that I would add, I mean, corporations are always trying to work their way around legislative barriers. That doesn't mean that's a reason not to put up a legislative barrier.
Absolutely. Well, I think we are out of time, so I'm going to add another thank you to all of our panelists for being here with us at Stetson. And Nathan, did you want to say anything else?
Well, I appreciate everyone, yes, for being here. And just to remind you, if you don't have to go to class now, the Committee of the Whole meeting at 1:45 at City Hall is open to the public, so the students are welcome to go as well. And clearly, this is an engaging and critical conversation. I think very few people have left for class, and if you want to continue being a part of the conversation, please come out tonight to Congregation Bethel at 7:30, where you'll see most of the panelists there as well. This is one of those few events where we have law students and so many folks from the community as well, and all the organizations that supported this. I really appreciate it very much. The League of Women Voters, American Promise, Free Speech for the People, and I also see we have a candidate for State House, Jennifer Webb came. This is a huge issue that the community of Gulfport came out to listen to, and I really appreciate that. On behalf of Stetson, for each of our speakers, I do have a thank you gift for each of our speakers.